We will not accept it. And here you go. Finally, just a slap across the face from the court system to say, stop it. Like a dog with a newspaper.
Yeah.
Stop it. This is another smack on the snout. We are the Armed Attorneys. Today we're talking about an important development in the FRT litigation. I like to think it's the first domino in what's going to be an effect that ends in very, very good news, not just for people who want to own and possess FRTs, but also for taking down the ATF's rules. But before we get started, show your support for the Second Amendment by hitting the like button. And today's episode is brought to you by Sonoran Desert Institute.
Sonoran Desert Institute offers online gunsmithing, armor courses, and so much more. Check them out at sdi.edu/armed-attorneys. And everyone, join me in welcoming back Miss Emily Taylor. Hello, Emily.
Hello. I am so happy to be back and so happy to not be pregnant for the first time in like 2 years. So
yes, to
this is
answer
pretty
all
good.
Yeah, to answer all the comments, we've seen them in virtually every video of the "Where's Emily?" Where's Emily been?
With her newborn.
All right.
So I have now 2 lovely babies at home within about 15 months of each other, 14 months. So I'm very, very busy, but I'm very happy to be back here doing this because it does not involve bottles, crying, or poop. So here I am.
Well, you don't know that. We haven't talked about the case yet.
Okay, fair enough. We might get, yep, sure enough.
All right, well, we're talking about FRTs today, forced reset triggers for the uninitiated. I need everybody to set their calendars for September the 27th, 2023. That's when we'll really get a bigger answer. But today we have a temporary restraining order. What's going on?
We do. So we have individuals who were in possession of force reset triggers. We also have some big national groups suing, but really, primarily, let's talk about the individual plaintiffs. So we've got these guys who say, I own forced reset triggers. I have to give them up to the ATF or else I'm going to face criminal prosecution. But I don't want to give them up because I'm going to face financial harm and other irreparable harms, I suppose, for having to surrender them. So they are suing in advance of surrender under the Administrative Procedures Act, essentially saying, hey, ATF, you made a rule that you're not allowed to make and it's unlawful and we want a court to issue a determination before we subject ourselves to criminal prosecution and, civil fines and all of that.
So the forced reset trigger, this is a drop-in trigger group. What it does is it utilizes the energy from the action of the firearm. It forces the trigger forward so that the shooter can then quickly depress it and fire more quickly. I've seen some people who are trained who utilize belt loops, all kinds of things. They could shoot very quickly, but allows folks to shoot more quickly, I would say, generally. But that's
right. It's a machine gun.
Yeah, that's the.
No, it's not a machine gun. That's
what the ATF is. That's what the ATF is alleging. And so this is a relatively new invention, right? And since we don't have time machines, can't go back to March 19th, 1986. These things weren't registered in the eyes of the ATF. They say these things are machine guns, which causes some problems.
Yes. So because of the Firearm Owner Protection Act, we have this provision in there that said machine guns that were not registered and in existence as of, I think it was May. Did
I say March?
You said March.
Oh, yeah, it's definitely May.
As of May of 1986 are unlawful. And of course, those that were registered and in existence in May of 1986 are still National Firearm Act items subject to a tax paid and transfer and registration requirements. But anything that would be a new machine gun is, of course, unlawful for civilian ownership, which means these brand new contraptions that we call force reset triggers, if in fact they are machine guns, they're not, but if they were, would be hot lava, all of them, unlawful, no way to make them lawful for civilian possession. And so once the ATF decided that they could sua sponte change the definition of machine gun, which is enacted by Congress, by the way. So do we let agencies just change legislation like that? No, we don't. That's not what rulemaking is for.
No. And so this really, I guess we could say it started back with this technical examination from July the 15th, 2021. The ATF said, we think these things are machine guns. They followed that up with a open letter to ATFs. This is March the 22nd, 2022, saying, hey, if you're going to sell these things, we're considering them machine guns. You're on notice these things are machine guns. Stop selling them. And so, I guess over the past year and a half or so, we've seen kind of a flurry of folks scrambling to get rid of these things,
Mhm.
surrender them to the
Right.
ATF. Yeah,
Confiscations by the
confiscations.
government
Yeah, and then enter the National Association.
without compensation.
Right. Enter the National Association of Gun Rights and these plaintiffs suing the ATF to, push the pause button on all this. And if you want to check the case out, it's out of the Northern District of Texas. This is case number 423CV00830-0. So if you wanted to check out and follow along as this case develops, that's where you check it out. They start off, and I think this is probably the more interesting part, and I'll have you talk about it, is the violation of the Administrative Procedures Act.
Often, particularly in Richard and I's world, when you see, lawsuits, it's because someone has already done something wrong.
Yeah.
That is not what we have here. We essentially have, under this very particular law, which holds administrative agencies to account in their rulemaking process. And there are lots of ways they can violate the Administrative Procedures Act, but we have this opportunity for plaintiffs to come in and say, "You are going to do me harm by your unlawful action," and the standing is there. I mean, gosh, I as a plaintiff could come in and say, "You didn't allow 30 days for comment.
Hmm.
My standing is there. You violated the Administrative Procedures Act." So we have these just beautiful plaintiffs with their hands perfectly clean, which shouldn't always matter, but often does in the
Yeah.
eyes of individual jurists. And this challenge, which is a very early challenge because we're in a temporary restraining order phase, not even at an injunction, which, by the way, if we're talking about good news, temporary restraining order, preliminary injunction, judgment at the trial
Yeah.
court
Permanent
level.
injunction.
Right, permanent injunction, judgment at the trial court level, a intermediate appellate court, Supreme Court, right? So we're talking about the first bit of good news in like a 6-year process, 7-year process, right? I mean,
Yeah.
am I undervaluing that?
No.
Okay. But still, why does it matter that we got this good news if I'm telling you it so early? And it's because when you're issuing restraining orders, when you're issuing injunctions, you have to do that with an eye towards who's gonna win at the end of the day. So we have this judge who shockingly is not Judge Pittman for once.
Yeah.
But
Reed O'Connor, appointed by Bush.
exactly. So we have Judge O'Connor saying, "Hey guys, I know this is a very early decision, but I'm making this decision because I've looked at the law and I'm telling you who's got the law on their side. And it's the guys who are the individual plaintiffs who want their FRTs. ATF, the law, federal government, the law is not on your side here. You have overstepped." And I'll tell you exactly what he says there. This is a beautiful, just little encapsulation of what's going on. The Administrative Procedures Act instructs courts to hold unlawful and set aside agency action found to be in excess of statutory jurisdiction, authority, or limitations. So that's what's being alleged here, right? The ATF messed up. They were not allowed to make the rule that they made, and now they are affecting people's lives with something they weren't allowed to do. Plaintiffs contend the ATF's regulation broadening the machine gun definition is an arbitrary and capricious expansion of the agency's authority. Plaintiffs are likely correct. That's the important part, is that to get this ball rolling, this judge has to think that we, the people, are going to win this at the end of the day and not let the ATF railroad us. And so that's why this is so exciting.
Yeah, and when we talk about FRT litigation, so what makes this a little bit complicated is, I think, and I don't, this is why you get two lawyers in a room and get multiple opinions. If the ATF was relying on just the old definition or the Congress definition of machine gun, there are arguments that, hey, they get there, and we don't need to look at the new bump stock regulation
Mhm.
or the wording for bump stocks. But you see that they changed the definition to try to scoop up bump stocks, and then we see the ATF change how they treat FRTs, and so whether they think that's encapsulated in the definition or not, or if they're trying to just not pass any kind of rule and then say these things are machine guns, I think there are some interesting arguments there.
Oh, yeah, certainly. And I think let's talk about Mike Cargill.
Yeah, yeah, that's
Were we always talking about Mike Cargill?
love me some Mike Cargill. Go get yourself a gun. And if you checked out the oral arguments to the bump stock case, Cargill v. Garland, on its way currently to the Supreme Court, with there being some other circuit courts of appeal that are disagreeing with the Fifth Circuit, you can tell that this court relied heavily on the
Mhm.
Cargill decision.
Well,
And
which they must. I mean,
yeah,
it's
which
Fifth
they
Circuit
yeah, it's
precedent. So.
binding. And when you listen to the oral arguments of that case, you can see how the wheels are turning in the minds of the judges. They see, hey, this isn't automatic. The shooter has to exert some force in order for this to function, just like a bump stock.
Yeah.
A bump stock isn't going to shoot itself. You have to push your shoulder into it. And I think they really hung their hat on that in the Cargill case. And I think when they are looking at FRTs, that's kind of the analysis they're taking.
Yes, which is at the time, I mean, go back in time with me to bump stocks. It just there is no state of the world in which the definition of machine gun encompasses anything else but a full auto sear and the way we traditionally understand machine guns, my opinion. And so, had Congress chosen to pass a law criminalizing bump stocks or the like, or something that would encompass FRTs, Congress very well could have done that. And bump stocks and FRTs would be illegal per statute. But that was not the will of Congress. It was not the will of the people, I suppose. I mean, if you get there, if you assume that our Congress people are doing our will. And so the ATF stepped in and said, we'll just do it for you, but they can't do that. And my God, it is time that someone stepped in and said, ATF, you are not allowed to do this to the population of the United States of America. We have constitutional protections against it. We will not accept it. And here you go. Finally, just a slap across the face from the court system to say, stop it. Like a dog with a newspaper.
Yeah.
Stop it. This is another smack on the snout.
Well, and I think another question, we got to answer the question: what is the scope of this temporary restraining order?
I got too wrapped up in the grand universe of why this is important. Okay, all right, yeah, nitty gritty.
But the scope of this is limited to the named plaintiffs in this case. Justin, we're talking about the temporary restraining order. Now, this September the 27th, 2023. That's the day that we may see what?
That's when this temporary restraining order will be in place for a specific period of time or until the court issues their preliminary injunction in the matter.
Yep.
Now, fast forward in time about a month from now, hopefully we will be talking to you again saying, guess what, guys? Everyone's FRTs are legal.
Yeah.
Go with God. Enjoy. That is not what we're saying today. This is just as to the individual plaintiffs in this case while we await the decision on the preliminary injunction.
Yeah. And at that point in time, I mean, the court's going to go one of two ways. Say, yes, we're going to enjoin them and we're going to keep it to these plaintiffs. They could say on a facial level, hey, FRT's good to go in the entire country. They could say that.
We always hope for that.
Yes, and that's exactly what we need to be on the lookout for. But this is, I think what's great about this is, and as far as I know, there are only a handful of people who have been criminally charged with the unlawful possession of a unregistered machine gun.
I wouldn't even call it a handful.
Right.
I mean, it's few.
I think it's one hand. I think we're talking about 3 people. As far as I'm aware, I mean, this isn't widespread criminal prosecution, but this is good because we're talking about, going after it in a civil venue before people are locked up, freedom deprived, fighting from the inside of a jail cell. It is so much more difficult under that context. So I'm really glad to see the National Association of Gun Rights being really proactive with this.
Very much.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please leave us a question, leave us a comment below. I'm so happy to be back with you guys, and hopefully I'll see you again very soon. Until next time, we're the Arms Attorneys.
All right.
Sweet.
Huzzah.